Thank you very much, Ken. I'm honored to be here today. I appreciate seeing so many people dedicated to fair housing. I'm short on time, so I have a lot of ground to cover, so I'm going to move through this pretty quickly. My name is Theresa Muley. I'm with the Department of Fair Employment and Housing. I'm based in Fremont, and we are the civil rights agency for the state of California. Pardon me. Oh. So, it's not advancing? Okay. 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 So the mission of the Department of Fair Employment and Housing is to protect Californians from discrimination, harassment, retaliation in employment, housing, and public accommodations, as well as to protect them from hate violence. The DFEH receives inquiries for housing and employment discrimination. We perfect complaints if it's a matter where we have jurisdiction. We investigate those matters. We attempt to settle those matters wherever possible. And if it's found that there's a merit case, we will file a lawsuit with the court system in the state of California. So Ken touched briefly on the different aspects of the law, but the HUD enforces the federal laws. The state of California has its own set of laws. It's enforced through the DFEH and the California Attorney General. Of course, there's local fair housing groups, and individuals can always file lawsuits. So the laws that are enforced by the DFEH include the Fair Employment and Housing Act, which is codified in the Government Code, the Disabled Persons Act, the Unruh Civil Rights Act, which relates to public accommodations, and the Ralph Civil Rights Act, which relates to hate violence. We have 3 offices in the state of California. One is in Fremont, one is in Oak Grove, and one is in Los Angeles. Here are the protected bases that we're concerned about in California. Disability, race, color, familial status, meaning members of the family that are under 18, gender, sex orientation, marital status, national origin, ancestry, religion, source of income, medical condition, age, gender identity, and gender expression, and genetic information. And as you'll see from the pie charts coming up, disability, race and color, and familial status make up the lion's share of the work that we do. And so I apologize, this pie chart is from 2013. We're gathering together the statistics for 2014, and hopefully we'll have that updated. But what you can see is that the majority of cases filed were based on disability and race and color. And then this next chart relates to complaints, civil complaints filed by the state of California, and you can see that familial status and sex orientation are very large components there. So this is a flow chart that relates to how we process matters, and in fact there's another step that's missing from here, which is when somebody has a claim of discrimination, harassment, or retaliation based on one of those protected classes, then they can file an inquiry with the DFEH. They can go online to our website, dfeh.ca.gov, and it's a very simple process to file online. Or they can call our 800 number and file an inquiry online. At that point, pardon me. Thank you. At that point, the intake team will have an interview with the person, will gather the facts and determine whether the state of California has jurisdiction over the matter and whether it's within the statute of limitations. If that is the case, we will perfect a complaint for the complaining party, and it will be turned over to an investigator who then will investigate the matter and also try to conciliate. If it turns out that there is evidence to support that a violation may have occurred, then we will take that to our legal department, and the legal department will first do mandatory mediation, which is free of charge to the parties, and if it's not able to settle at mediation, then they will file a lawsuit on behalf of the complaining party. So recently, gender expression and gender identity and genetic information were added to as protected bases. We also instituted a training program where we are training interns to deal with fair housing issues. We also offer webinars monthly. So if you go to our website, you can train employees and other people who are interested relating to sexual harassment and other fair housing issues. We also instituted about 2 years ago Houdini, which is a cloud-based electronic system that allows us to keep all of our records electronically. So we're trying to go paperless, and it helps in the efficient processing of matters so that we're not searching for files and we can keep all the evidence one place. So here's some examples of some fair housing cases that we worked on where we were able to obtain significant judgments and settlements. And these are in your material, so I'm not going to go over each one. Common issues that we deal with, if there are CC&R provisions that have race restrictions, obviously those are illegal. Familial status, we deal with cases where there are rules targeting children. So, for example, children cannot play in the common area. Children can't ride their skateboards or ride their bicycles, those types of things. Occupancy limits, we're concerned about those. And any type of rule or restriction regulating the behavior of children is something we'll look at. And that includes pool safety. Unlawful inquiries and advertisements are something that we would investigate. It's illegal to make an inquiry concerning disability, marital status, or other protected characteristic, and it's inappropriate and illegal to advertise the rental or sale of a housing accommodation which states a preference as far as the protected bases. And so, of course, there are exceptions to all these rules, but these are the general rules. Sexual harassment is unlawful for a housing provider to ask for a quid pro quo situation in exchange for housing rights or privileges. Familial status, as I mentioned, is having people under the age of 18 who reside in the property. And it also includes pregnant women or people who are in the process of adopting or seeking legal custody. Housing providers cannot refuse to rent or sell to people because they have minor children. The exception is senior housing. Making overly restrictive rules, we get a lot of cases regarding that. And it's amazing to see how many apartment complexes have rules that say the kids can't play in the common areas. It's amazing. It's inappropriate to segregate families that have children or otherwise restrict the rental to a certain area. We do quite a bit of disability discrimination, and so the way we analyze the cases under the California law is a disability is considered a mental or physical impairment or disorder that limits a major life activity, and it includes physical, mental, and social activities in working. We look at not only actual disabilities, but perceived disabilities as well. So if somebody is disabled and they ask for a reasonable accommodation at the request of that person, the housing provider must permit the reasonable accommodation unless they can demonstrate an undue financial hardship or administrative burden or a fundamental change in the nature of their program. And they may request verification from a medical provider that the person is disabled and has a need for the accommodation. And the housing provider is not entitled to specific information about the nature of the disability. And so a reasonable accommodation is a change in rules, policies, practices, or services when necessary. So examples of reasonable accommodations would be if a complex has a no pet policy and somebody has a companion animal and they make a request to keep the companion animal and they cannot be charged a pet deposit, they cannot be segregated, they cannot put breed restrictions or weight restrictions on that animal. Another example would be changing parking rules. If somebody has a mobility impairment and they need a closer parking space, and so it would be incumbent upon the housing provider to grant that accommodation request, and if they're unable to, then to engage in the interactive process to find an alternative. So a reasonable modification would be a physical change in the structure, so such as widening doorways, lowering cabinets, installing wheelchair ramp. And generally, the housing provider is not responsible for the cost and may require the premises to be restored to the original condition. Another thing that we look at is hate violence. And so if we have a complainant who is alleging that not only are they being discriminated against, but they're being threatened as a result of their protected basis, that's absolutely something that we would investigate. So common remedies include reimbursement for actual losses, emotional distress damages, access to housing if it was denied previously. We always, in every settlement that we craft, include policy and affirmative relief. So either a change in policy or fair housing training. It's possible also to get punitive damages, and as of January 2013, attorney's fees and costs if the DFEH prevails. So here are other resources. HUD and the DOJ issue joint statements that have a lot of very helpful information, particularly regarding disability discrimination. The State Bar of California, Housing and Public Accommodation subsection offers a lot of information. State Bar Real Property Law section. Our website, we have YouTube videos, we have a LinkedIn and Twitter page, and we have clinic and training materials. So that is it for my presentation. If anybody has questions, please fill them out on the index cards, and we'll be happy to address those. But